In the previous two videos on the topic of human rights, we tried to establish two things. The first was that in Islamic legal theory, rights are granted to every human being at birth, and these are embedded in human personality and the legal capacity of each human. The second point focused on the large uncharted area of permissibility, which contained all human rights, liberties and freedoms recognized by the Sharia. To give some structure to this uncharted area of permissibility, the famous jurist Al-Dabboosee examined human life beginning with the survival of the human being and its related requirements. His penetrating analysis led him to conclude that not only rational proofs, but also Sharia aimed at the preservation and protection of a number of basic things. These were life, the family, the intellect, property, and above all, deen, or the system of life of the Muslims. These ideas expressed around the year 1000 AD were picked up by many jurists. Among them were Sarakhsi, Juwayni, and Ghazali, all of whom lived in the 11th century AD. The efforts of these jurists led to what were later to be called the objectives or the Maqasid of the Sharia. Several centuries later, the well-known jurist Al-Shatibi elaborated this system of the objectives in different ways. It may be mentioned here that the uncharted area of permissibility also gave rise to what was called al-Shariah, or governance according to the Sharia. It was natural, therefore, that the theory of Maqasid or objectives came to be linked to the siyasa of the community. In this video, we will first describe the structure of the objectives as it was conceived by the jurists. This will be followed by an elaboration of the dual thrust of the Maqasid, which is essential for understanding how the rights, liberties, and freedoms of human beings are affirmed, as well as how they are defended when attacked. The Maqasid al-Shariah are the 5 ultimate principles that the Sharia places before us as objectives or goals to be achieved. The word qasd is also translated literally as intention. In this sense, these 5 principles reflect the intention of the lawgiver. Both meanings are used in different contexts. Islamic law upholds the principle of Maslahah, which some have incorrectly termed utility or public interest, and compared it to Bentham's principle of utility. The reason is that Maslahah, in its literal sense, means the acquisition of benefits and the repelling of harm, which sounds something like Bentham's pain and pleasure principle. The response to such thinking is given by Al-Ghazali, who defines Maslahah as follows. As for Maslahah, it is essentially an expression for the acquisition of benefit or the repulsion of harm, but that is not what we mean by it, because acquisition of benefit and the repulsion of harm represent human goals, that is, the welfare of humans through the attainment of these goals. What we mean by Maslahah, however, is the preservation of the objectives of the Sharia. Consequently, benefit and harm that affect human beings are not left to the human mind or reason. Rather, it is the Almighty Creator who has undertaken the task of identifying them himself. Muslim jurists have turned this principle, developed and refined over the first 5 centuries of the Hijrah, into a powerful system that not only determines legal rights within the Islamic legal system, but provides a framework of discretionary justice that takes over when man-made laws fail to provide remedies. The 5 principles then are: deen, or the system, has to be preserved and protected. Nafs, or life, has to be preserved and protected. Nasl, or progeny, or the family system, has to be preserved and protected. Aql, or intellect, or reason, has to be preserved and protected. Mal, or property, or wealth, has to be preserved and protected. Preserved and protected are 2 words indicating a similar meaning, but the jurists have indicated to us that these reflect 2 different faces of these principles. By preserved, we mean to affirm, to develop, and to make the system contained in the principle to grow to its full maturity and potential. By protection, we mean the defense of what has been developed. This is done by defending against invasions and by providing penalties and remedies for infringements and violations. We may examine the Maqasid from another perspective too. The term siyasa sharia means the policy of the Sharia. The policy is based on justice as long as the government upholds the Sharia. If it does not uphold it, the policy becomes unjust or zalima. The policy of the Sharia is of two types. The first deals with the preservation aspect of the 5 principles mentioned above, while the second deals with the protection aspect of these 5 principles. The policy dealing with the preservation aspect we may call the social policy of the Sharia. This policy identifies the goals to be attained by the system or the targets to be achieved by the imam or government. The duties of the government are contained in this policy. This public policy is relevant for the legislature and the executive, and they are duty-bound to uphold and implement this policy. Economists should focus on this aspect, while the legislators should convert what is deemed immediate into law or legislation. The executive must base its proposals and policies on this aspect and seek to implement it as far as possible. The policy dealing with the protection aspect we will call the legal policy of the Sharia. It consists of all the principles, presumptions, rules, and targets meant for the judicial system. This is the domain of the jurist, the judge, and the lawyer. They must always uphold them during adjudication and elaboration. As human rights, liberties, and freedoms are violated by the government, it is the courts that have to stand tall against these attacks and defend the rights and liberties against encroachment and attacks by government officials. It is to be noted that principles and rules contain rights, and thus the category of rights becomes directly relevant here. The legal policy of the common law has taken centuries to develop through the effort of the judges and lawyers. Islamic law is no different. It took the jurists centuries to refine these policies by going over the texts in minute detail and by issuing rulings spread over centuries. The difference between Islamic law and common law is that the social and legal policies of the Sharia were refined and fully developed long before common law was even born. And who knows, the common law may even have borrowed much from Islamic law. As some say, the word assis of the common law is nothing more than a translation of the word siyasa. The content of these policies has been described elsewhere under the heading of the 2 faces of the Maqasid. What was said there is briefly reproduced here with slight amendments. It was said, perhaps the most important feature of the Maqasid is their dual thrust. Al-Ghazali discusses this dual nature in detail in his book called Jawahir al-Quran. This point has been ignored by almost all the later jurists, except for al-Shatibi. The dual feature of the Maqasid is evident in the use of the terms ibqa and hifz, which we may call preservation and protection. Al-Shatibi considers these the 2 aspects of hifz. The first, he says, is what affirms its elements and establishes its foundations. The second is what repels actual or expected disharmony. The focus of later jurists, and hence that of modern scholars, has been on the aspect of protection alone. Each purpose, however, has a positive or aggressive aspect and a negative or defensive aspect. These are what we have now called the social policy and the legal policy of the Sharia. From the positive aspect, or the aspect of social policy, the interest is secured by establishing what is required by the Sharia through each of its Maqasid. Thus, the interest of deen is secured by the creation of conditions that facilitate worship and establish the other essential pillars of Islam. The interest of life is secured by creating conditions for the existence of life. The interest of progeny is supported by facilitating and establishing family life. The interest of intellect is secured by promoting the means for the growth of the intellect. The interest of property is secured by creating proper conditions for the growth of wealth. From the defensive or the protective aspect, which we have now called the legal policy, interests are secured by preventing the destruction or corruption of the positive aspect. Thus, jihad is prescribed for defending deen, while prayer, fasting, pilgrimage, and zakat help establish it. It is the duty of the imam to ensure proper conditions for both, while it is binding upon each subject to fulfill these duties individually and collectively. Life is preserved through the provision of sustenance and the maintenance of good health, while it is protected or defended through the provision of penalties for those who destroy life without legal justification. Nestle is promoted through the maintenance of healthy family life in the institution of marriage, while penalties are provided for those who would corrupt it and destroy its values. The preservation of aql is achieved through the provision of education and healthy conditions for its growth, while penalties are provided for the consumption of substances that destroy the intellect. Preservation of wealth is achieved by encouraging its growth, while theft or misappropriation of wealth is punished through penalties. It is to be noted that al-Sarakhsi has called each separate purpose a policy. He refers to them collectively as siyasat or policies. Work needs to be done to work out the details of each policy. Finally, we may take up an example to drive home a very important point. Let us say that the fourth principle of preservation and protection of the intellect requires that there be complete freedom of expression and speech as long as the rights of others are not violated. In case the government tramples upon these rights or tries to unduly restrict them, it is incumbent upon the courts to take remedial action against the government. The same is to be said about the right to education and a free environment for development of the mental faculties. The right to the education of the child may be drawn from here, as well as from the third principle that gives great importance to the rearing of the child. The point to be made here is that naming these rights or claiming that they exist under the Maqasid is not an area where anyone can get up and claim that such rights exist and are to be protected. It is similar to what some people have started doing after discovering traditions mentioned online to claim the existence of a law or laws and should be followed or others should not be followed. The jurists realize that something like this may happen over time. They have left a detailed methodology as to how a certain right or legal rule is to be claimed to exist under these 5 broad heads. In our next video, we will turn to how these policies are to be used for creating new laws, rights and liberties,